Hello and welcome to another edition of Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at Nachman, Polwani, Zimochek, and today I'm joined by Felicia Zeidman, one of the other attorneys here in our office. Felicia is a U.S. attorney and also a Canadian attorney. And I just want to remind our viewers that we have an office here in northern New Jersey. We also have offices in Midtown Manhattan, and we have satellite offices located in, affiliated offices in Canada and also in Mumbai, India. So today, Felicia and I were speaking, and we thought it would be a good idea to bring to your attention some of the recent updates with regard to the Form I-9 arena. And there was a case that came out on August 20th, and that's only a couple of days ago. And the case is called Platinum Builders of Central Florida. And Platinum Builders of Central Florida was kind of what's referred to in our, I guess in our parlance, as a landmark case, because what it did is it started to address what are considered to be procedural and technical violations and gave us a little more guidance than we had before. The only guidance that we really had with regard to what is considered a procedural or technical violation had come out of the Virtue Memo, which dated back many, many years. It actually dated back, I believe, to the late 90s. So it went back quite a ways. But what this case does is it gives us a new view about what is procedural and technical violations. But basically what happened in this case is that a construction organization located in Florida was served with a penalty of, I believe, about $70,000, which is very significant. Is that about $70,000? I think that was the penalty. And at the end of the day, after the administrative law judge had dealt with these issues, it was substantially reduced, which of course gives some hope to some of the employers out there who are viewing this video that there are ways in which there can be reductions. Now I know that Felicia wants to tell you a couple of things about the case and points of interest, so with that I'm going to turn it over to Felicia.
What I'd actually like to address is a recent decision in the federal court of August 6th, because the federal court is the court that trumps all decision-making that's been made before in the I-9 arena. Right,
and maybe what we should do is, just so that our viewers understand, what this is this arena is in the area of administrative law. And so the way that it would be handled is that the Immigration Customs Enforcement would come in, serve you with a notice, and then of course if it gets to the point where it's unable to be settled, it would be heard in front of an administrative law judge. And then if the decision of the administrative law judge is sought to be challenged by the organization that's being fined, they can do that in the federal court. And that's what Felicia is referring to as this case on August 6th, where it was in fact challenged in the federal court.
So the federal court decision that was made on August 6th was called Ketchikan, and that's also a construction company. In fact, Ketchikan only had 4 full-time and 20 part-time employees. That at the time that the decision was made, they had many fly-by-night employees for projects on a project-by-project basis, and their fines had been assessed by ICE at around $173,000. So here you have a company with 4 full-time employees looking at $173,000 in fines, because of course they'd had a rotating batch of employees and they'd been making out I-9s that were not accurate and not according to regulation for all these employees they had. Now that Ketchikan decision laid out a number of important principles, and one of the principles was that photocopying documents is of limited use. It really specifies the List A, List B, and List C documents, and the documents that the photocopies have to be attached to the I-9 itself. Otherwise, they have extremely limited use, if at all, and they have to be given over at the time that ICE comes to collect documents. And that's at the notice of inspection period. As we've discussed I-9s before, the notice of inspection period happens first, and then ICE reviews everything, and if there's going to be a fine, they assess fine. The notice of inspection period, often employees sort of throw their hands up and don't know, HR employees, excuse me, throw their hands up and they don't know exactly what to give over to ICE. And they're nervous about giving their documents to the government. Who can blame them? And I think it's at that period, actually, that great care has to be taken to give ICE everything that they're asking for, but not more. And it's obviously a line that's difficult to assess, and it's useful to consult with an attorney at that point in particular, because you want to make sure you're giving ICE everything that they're asking for. So that's at the notice of inspection period.
And I think it's important to point out also that what in that case, that the copy issue had to do with individuals where copies were made, but the I-9 forms were not actually filled out. Right. So what happened there was that the employer made copies of the individual's documents, attached them to the form, and felt that that was going to be sufficient. But the problem is, and while it's true that if you have an I-9 form where you've made a good faith effort to fill out section 1 and 2, and then you attach the documents, you can obviously use the documents to make the good faith effort to comply under the Bono Amendment, and you can try to cure those procedural or non-substantive violations. In this case, unfortunately, they didn't fill it out at all. They thought that by just attaching it, that would be sufficient.
And it's easy to understand, from my perspective, why an employer would think that photocopying the documents is important. After all, what ICE and the government are after is to confirm that the people that you're hiring are actually American, are authorized American workers, be they citizens, permanent residents, or people with visas. That's really, it would seem, what the philosophy is behind having the I-9 form, but in fact, the I-9 form has become a creature of itself, where filling it out properly is also very important to the government, not just why we're filling out the I-9 as a society, but also the fact that you have to abide by a government regulation. You have to fill out that form. So keep that in mind, and don't disregard the requirement to fill out the I-9 and the requirement to learn how to fill out the I-9. All of that education is very important for you and whoever is handling the human resources function at your office.
Just as a quick tidbit, we've said it in other videos to our viewers, the I-9 form emanates from the Immigration Reform and Control Act, IRCA, which was passed on November 7th of 1986, that made the employers the watchdogs to ensure that individuals who are not work authorized were not hired. And what you should do is, if you're not familiar with the I-9 process, we encourage you to get online the M274 document from the USCIS website. It's under www.uscis.gov. Go to Forms, scroll down to M274 and print that out. That's the I-9 Bible. Take a look at that document, read it well, and get to know it, because that's going to be your training manual on how to do the I-9 forms for your staff.
It's easy enough to read. It is long, but it's easy, and it will help you understand how to fill out the I-9 and where to go if you have any questions. You certainly would be well set up to read it. It's a little bit of an investment, but it's a massive payoff. So it is highly recommended. I just want to take a step back, because we're getting into a little bit of a lengthy video here about the decision, the Ketchikan decision at the federal court level, and something very important that was said in that decision. The administrative law judge who handles matters that get to a court about I-9s, I mean, often I-9 fines are assessed, and people may pay them to ICE, or they may negotiate with ICE and come to a certain cost agreement. But let's say that there's a disagreement completely about liability on these fines, and the employer decides to take this matter to court. There's a special court that decides it, and that court has been given vast deference to make decisions by the Superior Court, the federal court that reviewed the decision in this Ketchikan matter. So what that means is that we have to pay very special attention to what what is coming out of that special court and the judge's decisions and how much she is assessing in those fines. It is a very specialized court. All the players in that court understand the I-9 and everything around it completely, and this is all they do. And so they are granted the power to make decisions about fines. So that's another reason actually to contact a lawyer, because the wind blows differently about how the fines are going at any particular time. And as you're assessing for your own company where you're going to go with this fine, if you're going to enter into some kind of protracted negotiation process or a protracted review of your own I-9s and trying to deal with ICE on your own or through a lawyer, you might want to talk to a lawyer again to find out where what's the latest updates on how the administrative law judge is making her decisions. In our office, we're extremely vigilant about watching where the decisions are going, because we need to know for our clients and for our understanding of the arena. So contact a firm that's spending a lot of time on the I-9 process, because these are the people who are watching these decisions, and the decisions are coming out, and in fact they're coming out fast and furious, much faster than I've ever seen them before. And as we've mentioned on other videos, this is an area that's likely to get even more busy because of the specter of comprehensive immigration reform and what that's going to mean for monitoring the nation's workers.
So specifically with regard to the Platinum case, we just want to point out to you, this is a one of these recent cases that Felicia's referring to, and in that case there was a distinction drawn with regard to substantive and procedural and non-technical violations. And so what essentially the case says is that you can mitigate procedural or technical violations. You cannot mitigate substantive violations, and it's pretty clear that that is sort of the holding under the law. So as Felicia properly points out, that an analysis has to be done as to whether or not the deficiencies in your I-9s are considered to be technical, non-technical, substantive, or procedural. Then a determination needs to be made as to whether or not mitigation is possible, and there's a four-pronged test with regard to mitigation that can be argued before the immigration judge, the administrative law judge, and those are: number one, the size of the business; number two, the potential financial impact on the business; number three is whether or not bad faith or good faith is exercised. And actually this case speaks to whether or not, and actually a lot of the cases speak to whether or not there's bad faith. And what we're sort of seeing is that the judge seems to say that just the lack of doing I-9s doesn't seem to be bad faith or bad motive, and that's a really good thing that's come out of these cases. So with that, I'd like to thank you very much for tuning in for this great information about the I-9 process. I'd like to, if you have any questions, I'd like to invite you to contact either Felicia or I at our law firm. Please stay tuned for additional updates with regard to the Form I-9 and some of the recent releases and the state of the law. Thanks very much for tuning in today. Bye now.
Thank you.